Good morning, everyone. I'm going to wait a few more moments so that everyone can join the virtual room here and connect with their audio.
Good morning.
Good morning.
This is Chelsea O'Sullivan.
Thank you. We're going to get started in just a few moments. I was giving everyone a few minutes to get settled and connected here.
Thank you.
All right, I'm going to go ahead and get started. It looks like we have everyone out of the waiting room, at least for now. So good morning. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. It is April 27th, 2023 at about 10 o'clock in the morning. This matter has been reassigned to me by the former presiding hearing officer of the AHO, and I will be the hearing officer for this proceeding moving forward. So it is nice to meet all of you. I know you've been working together for some time on this, so I am happy to be joining the group here. This is a pre-hearing conference on the pending petition for change by City of Solvang of Water Rate Permit 15878, which authorizes diversions of water from the Santa Ynez River in Santa Barbara County. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you are experiencing technical difficulties today trying to communicate with us during this pre-hearing conference, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov. AHO staff will be monitoring that email inbox. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Amy Blunk, Skylar Anderson, and Kyle Woldrich. I'd like to go ahead and move to appearances. To do that, I'm going to identify each of the entities that have filed NOIs or are otherwise on our service list. And as I do, if you are representing that entity today, please unmute your microphone and state your name. As we proceed, please do keep your microphone muted unless you're speaking so that we can minimize background noise with all of us here in the virtual room. So I'll go ahead and get started with the City of Solvang.
Good morning. My name is Chelsea O'Sullivan, and I am the Assistant City Attorney for the City of Solvang, and I work for Richards, Watson, and Gershon.
Good morning. This is Tilden Kim, also with Richards, Watson, and Gershon, co-counsel with Ms. O'Sullivan representing City of Solvang.
Thank you. Good morning, Ms. O'Sullivan and Mr. Kim.
And I believe also Jose Acosta of the City of Solvang is also present.
Thank you. Mr. Acosta, do you care to introduce yourself this morning?
I'm Jose Acosta. I'm the Utility Director for the City of Solvang. Thank you.
Thank you. Welcome, Mr. Acosta. Next on my list is the Alisal Guest Ranch.
Good morning, Jessica Diaz with Brownstein Hyatt Farber Schreck representing the Alisal Guest Ranch.
Thank you. Good morning, Ms. Diaz. Santa Ynez River Water Conservation District ID number 1.
Good morning. This is Gary Kvistad with Brownstein Hyatt Farber Schreck representing ID 1.
Thank you. Good morning, Mr. Kvistad.
And this is Elizabeth Esposito, also with Brownstein representing ID 1.
Thank you, Ms. Esposito.
And good morning. This is Peter Garcia. I'm the General Manager of ID 1. Nice to meet you and nice to see everyone.
Thank you, Mr. Garcia. Now moving on to National Marine Fisheries Service.
Hi, this is Lori Beal. I am with the National Oceanic and Atmospheric Administration, or what we call NOAA, Office of General Counsel, on behalf of the National Marine Fisheries Service. Thank you.
Thank you. Good morning, Ms. Beal. California Trout.
Good morning. I'm Maggie Hall from the Environmental Defense Center on behalf of California Trout.
Thank you. Good morning. Santa Ynez River Water Conservation District.
Good morning. This is Brett Stroud of Young Wooldridge, General Counsel for the parent district.
Thank you. Good morning. And California Department of Fish and Wildlife.
Lena Germanario, attorney for California Department of Fish and Wildlife.
Thank you. Good morning.
Matthew Jones, also with the Office of General Counsel, CDFW.
Thank you very much. Good morning. And with that, is there anyone else on the call who plans to participate in the pre-hearing conference today who has not yet had the opportunity to introduce themselves?
Hi, this is Steve Gibson with California Department of Fish and Wildlife. I'm an environmental scientist in Habitat Conservation Planning Branch.
Thank you very much. Good morning, Mr. Gibson.
Good morning. My name is Kyle Evans. I'm the supervisor for steelhead recovery and restoration with the California Department of Fish and Wildlife.
Thank you. Good morning, Mr. Evans.
And my name is Erin Wilson. I'm the Environmental Program Manager for Habitat Conservation Planning as well for CDFW.
Thank you. Good morning.
Good morning.
Okay, I'll go ahead and move to the substance of our meeting today. As I mentioned, I am somewhat new to this proceeding, but I've been reviewing the administrative record and getting up to speed on where we are. I have been preparing a notice of hearing in this matter. That seems to be the next step in this proceeding. And I wanted to meet first. The reason I scheduled this pre-hearing conference was a chance to meet first and discuss the questions that I identified in the notice of pre-hearing conference that I issued on March 24th. It seemed more efficient to talk about some of those issues first before I memorialize those in a notice of hearing. But I do want to say what my plan is to issue a notice of hearing at some point and then allow for additional opportunity to make amendments to that if it's appropriate, especially if we end up scheduling this out. It sounds like possibly in November, which gives us plenty of time. I did receive pre-hearing conference statements from the City of Solvang and a joint statement from Cal Trout, NIMS, and California Department of Fish and Wildlife. I appreciated both of those, and I did read them carefully and use them to help prepare me for this meeting today. So feel free to refer to those. I know there are a lot of issues to talk. I mean, they're procedural and kind of, I don't want to say small issues, but we have a lot to work through today. So please remind me if I seem to have missed something in your pre-hearing conference statements. I first thought it would be useful for me to get a better understanding or confirm my understanding of the participation of the Alisal Guest Ranch and Improvement District Number 1. I understand both parties have entered into a settlement agreement with Solvang. So I wondered if you would clarify for me, to the extent you're able, and this is not a commitment, but just for my understanding, the extent that you anticipate of your participation in any hearing, whether you would be planning to put on, at this time, to put on any evidence, or whether you would be participating in more of a less active role, I guess I could say. You know, you may have cross-examination and that type of thing, but not in the sense of presenting witnesses or other evidence. So maybe first I'll turn to Ms. Diaz on behalf of the Alisal Guest Ranch, if you would.
Good morning. Thank you, Ms. Quincy. Jessica Diaz for Alisal Guest Ranch. So I would say we will definitely continue to participate in status conferences and intend to monitor the proceedings. And I think would like to reserve our rights to submit potentially rebuttal or other evidence depending on what else gets submitted by the other parties, and certainly reserve our rights to participate in the hearing to the extent there are issues that arise that are germane to this settlement agreement or have impacts on Alisal Guest Ranch. So I apologize if that wasn't fully committal.
Yep, I completely understand that it's difficult to commit at this time, but I think that confirms what I anticipated your participation might be. So that's helpful. And then I will turn next to Mr. Kvistad. If you would just confirm on behalf of the, what are we calling this? Maybe also, can you confirm what is a good shorthand for your client's name?
ID1.
ID1, thank you. That's easy.
Yeah, I think what Ms. Diaz indicated is correct. In our notice of the settlement to the AHL's office, we indicated we're reserving our right to participate to the extent that anything that in proceedings are inconsistent with our settlement with Solvang and Alisol. And second, if there are any issues that are adversely impact ID1. At this time, as Ms. Diaz indicated, we intend to monitor the proceedings, and that our participation will depend upon what, if any, issues come up during those proceedings, and to that extent, how we would intend to address them.
Thank you. That's helpful. I appreciate that. The next on my list, I have two items that I wanted to clarify, I think, for our discussion, which might be helpful in terms of the procedures or what has become normal procedures before the AHO. I realize this proceeding, I think, was one of our, maybe the first proceeding on the AHO docket, but in the last 3+ years, we've developed some practices. So I first wanted to clarify my intent, absent objection, to conduct the hearing by Zoom. This has been the practice of the AHO for all of our hearings to date. It seems to work very well. The way we usually do that is that a member of our staff, Nicole Mullen, handles the exhibits. And so during, for example, during presentation by a witness or cross-examination and similar things, the witness or the attorney can simply ask Ms. Mullen to bring up exhibit whatever number it is. And that seems to work very well. And that's what we have been doing and have done in the past. So my intent would be to conduct the hearing by Zoom. Generally speaking, everyone seems to like this, and it reduces the cost, of course, and reduces the difficulty in scheduling a hearing. Of course, if there are any objections to conducting the hearing by Zoom, I certainly would consider those objections as we move forward and then make a determination whether to conduct any or all or any portion of the hearing in person. But my presumption would be absent any objection that we will have a fully remote hearing. The second issue I wanted to clarify is that the normal practice for State Water Board hearings in general, and also for AHO hearings, has been for witness testimony to be submitted in advance in writing, which means that there is no direct examination of these witnesses. There is an opportunity, typically during the hearing, there's an opportunity for those witnesses to provide a very brief summary of their written testimony. This can be helpful to orient me and everyone else at times, but in some instances, we find that to be unnecessary and the witnesses don't provide a summary and we move actually directly to cross-examination. So I wanted to clarify that normally there is not time for what you would normally call a direct examination. That's not an element. In the past, I have typically allowed a party 1 hour to present the summaries of all of their witnesses' written testimony. That's sort of a general sense. So if you were to have 4 witnesses, you could divvy it up accordingly, 15 minutes roughly, if that was appropriate. I always encourage parties to be efficient. I will have read the written testimony in advance of the hearing. And my team will have read that written testimony as well. So I will commit that I'll be familiar with it. But sometimes it is helpful to have those summaries. We also find if there is a summary, it is often helpful for the witness to provide a PowerPoint presentation to go with that summary. This can be useful to bring up key exhibits such as maps, particularly, and graphs, other types of graphical information that's best conveyed with a picture. And I do ask for those PowerPoint presentations to be submitted with the exhibits. So the PowerPoint presentation itself is an exhibit in the proceeding and submitted as an exhibit with the witness's written testimony. And then those can be used to facilitate the presentation of a summary of that written testimony. So with that background, I know that's a lot of information. I'm happy to answer more questions. I realize we don't, there was an old hearing notice in this proceeding, but you don't have an updated hearing notice. As I said, my intent is going to be to issue a hearing notice and then have us, I think what I'd like to do is have us reconvene. And if there are changes or questions or anything related to that hearing notice, we can address those at that time. But I think right now what I'd like to do is jump into the issues that I identified in the pre-hearing conference notice. The first issue was when we should conduct a hearing. And I think I asked how many days, although I realize that's a little difficult to answer without knowing how many witnesses we're going to have. But we can talk about that. The city suggested in their pre-hearing conference that we look to November 2023 for a hearing. I had anticipated, of course, that the summer was not going to be a good time for a hearing, and we were looking at the fall regardless. So I am not, from my perspective, I'm not opposed to waiting until November. Maybe at this time I will turn to the other parties. I don't know, the three interests who submitted a joint statement. I guess I can go through each of you in turn if that makes sense. But maybe first I'll turn to NIMS and ask whether you have any objection to scheduling this hearing for November 2023.
No, we don't have an objection.
Okay.
Oh, and I might as well just add that NIMS anticipates having one expert witness testify.
Thank you. That's helpful. California trout.
No objection to November, but in terms of how the rest of the schedule would pan out in relationship to that, we do need some information from our expert about his availability in December. My understanding is that he would not be available all 4 of the days if there was a rebuttal hearing in December following the November hearing, but he could be available a couple days at that time. So kind of contingent on how the rest of the schedule would play out.
I see. So that's another piece of this question, which is if we start the hearing in November, when do we end the hearing? And how do we schedule rebuttal in relation to the case in chief portion of the hearing? But maybe let's go through this exercise first. We'll try to do this in an orderly way, and then we'll come back to the question of how to schedule rebuttal. I'll turn next to CDFW. Do you have any comments or so far about looking to begin the hearing in November?
So we would be comfortable with the case in chief hearing being scheduled for, say, the beginning of November. I think if we get later into the month, we may have to double check with some of our staff. But we had sort of sketched out, 1st through 7th, excluding weekends. And then, our presumption is the rebuttal hearing may then be in early December. And I think those should generally work for us as well.
Okay. Thank you. I mean, I'll try to not jam us up over Thanksgiving. I know that's difficult for everyone. We're working, the advantage of working this far out is we can hopefully set a schedule that is somewhat convenient for everyone. Just proceeding along in my list here, I'll go to the Santa Ynez River Water Conservation District. Any concerns or comments?
No concerns at this point. This general procedure worked very well in the proceedings we've been involved in on the Kern and the Kings. The November timeframe makes sense to me. I would add the Santa Ynez current intention is to perhaps participate in cross-examination, and depending on what's submitted, perhaps we'll have rebuttal testimony. So I would like to know, would you anticipate written rebuttal testimony being submitted before the case in chief hearing or between the case in chief hearing and the rebuttal hearing?
And that's a good, thank you. That's a good question. Maybe I'll start with some comments. I realize we haven't worked through this quite, but we'll keep this going. Everyone will have a chance to comment on all of these issues. I think the proposal we got from the city was to have the case in chief testimony submitted in September, rebuttal testimony then submitted in October, which would mean that you would be going into rebuttal without having the opportunity for cross-examination of the case in chief witnesses. So you'd have to submit your rebuttal testimony without having completed cross-examination, which may be fine, it depends, but that's something for your consideration. And then we would begin the hearing in November. And if that were the setup, I think we'd just sort of march right through the proceed. I mean, we could have case in chief witnesses and then march right into rebuttal. There would really be no reason to have a pause. Another way to do this is to start with the case in chief portion of the proceeding, complete that, and then have the deadline for rebuttal evidence. And then have a separate, as has been discussed today, but about a month later, complete the rebuttal portion of the hearing with a few days. So that's two different ways to do it. I think I've done both in different proceedings. It just depends on the proceeding, what works best. So I think that is an issue to be decided. So let's continue to talk about that as we move through. And as I said, there'll be a chance for everyone to come around. So I'm just going to come around again on everything we've discussed so far and move on to the Alisal Guest Ranch. Any comments on what we've discussed so far?
No comments from Alisal. We're comfortable with the discussion thus far.
Okay, thank you. And then ID number 1, or ID1 is the shorthand, ID1.
Yes. No, we're fine with that that schedule that you've laid out so far.
Thank you. And then with that, I'll turn back to the city of Solvang. Based on our discussion, do you have any thoughts about this? I know you suggested November, so I assume you're on board with that. But do you have any thoughts about how to schedule rebuttal or preferences based on our discussion so far?
Thank you. Yes, of course, we're definitely okay with the November timeframe as we kind of worked that out on our schedules as well. As far as rebuttal, you know, with our experience and other proceedings and with the prior notice issued by Mr. Lilly in this proceeding, we also have seen it both ways. Yeah, I think we decided to go with offering the more streamlined approach. But, you know, I think we can be open to discussions. Just, it seemed easier to schedule one set of hearing dates because, you know, briefing schedules are easier for people to work around with vacation and staffing and whatnot. But I don't know, Tilden, do you have any other comments?
Thanks, Chelsea. So while this is my first appearance before a State Water Board application hearing, the way that this is set up, it seems very similar to the proceedings that I've been involved in before the CPUC, you know, with the presentation of direct testimony in written form. And the ones that I've been involved in at the CPUC have been, as we had outlined in our pre-hearing conference statement, basically the submissions of direct and rebuttal, and then the hearings thereafter with the both the direct and rebuttal witness cross-examination. It's just, in my experience before the CPC, you know, that's how it's gone, and it has worked so far in the proceedings that I've been in, and seems a lot more streamlined and efficient than staggering the hearings the other way around. So while we're not adverse to the other staggered proceeding, we just think it's a lot more efficient to have both the direct and rebuttal testimony in written form submitted, and then hearings thereafter for cross-examination of all witnesses.
Thank you, Mr. Kim. That's helpful. I think in my thinking on this and thinking this through, and I turn to the room again, I agree. It is, in my opinion, more efficient to run the proceeding in this way, where we have all of the submission of evidence, both direct, case in chief, and rebuttal in advance. We can deal with all the evidentiary, if there are any evidentiary motions in advance, and then we can conduct the hearing pretty directly moving forward. The nice thing is we can block out hearing days, and we don't have to identify necessarily whether they're for case in chief or rebuttal, because we move through it. When I have done this in other proceedings, there is, of course, I have held the caveat that if something comes up in cross-examination that was not anticipated, it was not in the direct written testimony of the witness, some new issue comes out on cross-examination, well, then that would potentially be a good cause to allow additional time to submit additional rebuttal evidence, right? If there's some issue that couldn't have been anticipated and is new information, that would be potentially appropriate, and we would deal with that as it comes on. Whether that means having to schedule additional hearing days, we can do that. So there is that caveat, and it does, I think, work pretty efficiently. With that said, I think what I'd like to do is go back around the room. I don't know if I can remember what order I went in before, but I'll try. Don't let me skip any. Feel free to speak up if you think I'm missing you. But I will first turn to National Marine Fisheries Service. My question right now that I'd like to talk about is whether it makes sense to have the submission of direct testimony and rebuttal in advance of the beginning of the hearing, or whether we should schedule this so that rebuttal evidence is submitted after we've conducted the hearing days on the case in chief portion. We would then have submission of rebuttal evidence and then conduct the rebuttal portion of the hearing. So, Nymphs, do you have any comments on this issue? Ms. Beal, I believe you're on mute.
I have not personally participated in a hearing that involved written rebuttals submitted in advance of cross-examination. Only hearings I've had, we've had the benefit of the cross-examination to inform the rebuttal. I don't have any strong, opposition to trying it, although I have a little bit of concern about, especially since we're looking at trying to get things done within a time frame that involves a lot of holidays and difficulties in scheduling, that while it might end up being more efficient, it could also end up being very difficult to figure out how to have some sort of rebuttal testimony, and whether that involves only written testimony or requires bringing the witnesses back, and how we would schedule that. But again, that's sort of, I guess, my 2 cents. Thank you.
Thank you. And I realize we're all working through this together. California Trout, I will turn to you next.
Thank you. I share Ms. Beal's concerns and position. I also haven't been in that position before, so don't feel strongly about structuring it one way or the other. But I also understand that the plan would be for Cal Trout, Nymphs, and CDFW to submit joint evidence. So I think it would be helpful for us to at least be kind of all on the same page about what we think the best approach is.
Thank you. CDFW.
Yeah, I would say we echo Nymph's concern. I think, if I'm understanding correctly, the concern is essentially if something new comes up in cross and there was a need for further hearing dates, scheduling of that at a short notice could be challenging, especially since we're working together jointly. But beyond that, I don't think we have a strong preference either way.
Thank you. Santa Ynez River Water Conservation District.
I've done both. If I'm not mistaken, I've done both with you as the hearing officer, because I think in the Kings you did them back to back, and in the Kern we did the delay. And I think both work. I think I'm probably inclined to say that the back to back worked better. I think, especially given your caveat that rebuttal witnesses could testify to some things that came up on cross. I think that probably solves it as far as I'm concerned, but I think both approaches work.
Thank you. Let's see, let's go to the Alisal Guest Ranch.
Alisal's open to both approaches.
Thank you. And then ID1.
We're fine with either way.
Okay, thank you. So I think what I'm going to do, at least for now, and as I said, I anticipate we'll schedule another pre-hearing conference after I issue the hearing notice. And this will be an opportunity to amend the hearing notice once you have a chance to look at it on paper and see how all of the deadlines interact, how the timing for witnesses, things like, things come up when you have a chance to look at it, and we do have time here. What I anticipate doing here is scheduling this out as what we're calling a back-to-back, where we would have deadlines for the submission of the case in chief testimony and exhibits, and then a deadline for submission of rebuttal testimony and exhibits in advance of the beginning of the hearing, and then schedule hearing days in early November. What I might do is schedule a holdout hearing day somewhere a little bit later, just so we can mark it on our calendars so we have it. And that may give us some comfort that if we need that additional hearing day, we have it. And it could be maybe, I'll have to see how it interacts with the holiday, but 2 weeks out from the block that we set off in November. Hopefully we won't need it, and then we'll just cancel it. But that might be a way to hold all of our calendars and give us to make sure that we can complete all of this before the holidays and are not trying to schedule hearing days in November to happen before Christmas. There's this question of how many hearing days, one for the case in chief and then for rebuttal. As I mentioned, if there's just summaries of written testimony for the witnesses, that usually moves pretty quickly. It sounds like we'll have a presentation from the city of Solvang and a joint presentation of some kind from NIMS, CalTrout, and CDFW. So really the bulk of the hearing is cross-examination. And of course, that depends on how many witnesses we have. But what I'd be inclined to do is schedule approximately 3 days for case in chief and 2 days for rebuttal. I think there was one thought if City of Solvang had 3 witnesses and the other parties had 4, 7 witnesses, it seems that we should be able to get through cross-examination. It's almost half a day for each witness. I mean, there may be some procedural issues we have to work on. And then hopefully by rebuttal, this has whittled itself down quite a bit. I do find that however many days of hearing we schedule is however many days it takes, right? If we schedule 10, it's going to take 10. If we schedule 5, we'll manage to do it in 5. But I want to do something reasonable so that we're not really, I want there to be ample opportunity for cross-examination. That's really what the hearing is for. So on those thoughts of how many days to schedule at this time, and then with the caveat that I will look at scheduling an additional day out about 2 weeks from whatever block of time we look at. I would not do 5 days back to back. I've done that, and it's really hard on everyone. So we'll have, maybe we'll do 3 days and then 2 days, or maybe 2 days and then a day and then a day off, it's something reasonable so that we aren't going straight through, I'm not going to schedule it straight through in 1 week, 5 days in a row. If I'm going to go around the room, I think we might as well look at our calendars. And you can talk to me about what you think is a reasonable number of days. And then you can also please let me know if you have concerns about particular days or conflicts, I should say, unavoidable conflicts on particular days between November 1st and let's see, November 10th is a state holiday. So between November 1st and November 9th. I think that's in that window is when I'd like to schedule the hearing. So with that, I'll turn first to the city of Solvang. Any comments on the number of days or that window of time from November 1 to November 9?
Thank you. The number of days seems reasonable. I mean, I think once we have a better idea of the total number of witnesses, but 5 days, if we're estimating about 7, that sounds about right. And then I personally do not have any conflicts in that time frame of November 1st through the 9th.
Thank you. I will turn next to NIMS. Ms. Beal.
Yes, I'm sorry, I was just unmuting. I have like double, I have 2 things I need to do to unmute. So November 3rd, NIMS expert witness is not available. That's the only exception we have. Otherwise, those dates are acceptable.
Thank you. I think too, if I end up scheduling November 3rd as a hearing day, I think it's a Friday, so I may not, but if I do, I'll keep that in mind and we can work around that for the presentation of NIMS expert witness. Next, I will turn to California Trout.
Thank you. I have no conflicts on any of those days personally, and I would just have to double check with our expert witness, who I know is generally available in that time period, but has some concerns about, the back-to-back days. So it would kind of depend on how many back-to-back days he would be needed.
Understood. And Mr. Kim, I saw you have a comment. Please go ahead.
Thank you. So just wanted to echo the reservation of several other people that we don't have the calendars of all our witnesses, especially experts, in front of us. So probably the best thing to do is we probably need to revisit that at the the follow-up pre-hearing conference, so that by that time we'll have cleared those dates or approach our experts and witnesses with those dates, and then we can revisit availability at the next scheduling conference that it looks like it's probably going to be in July or something like that. And then lastly, fully appreciate not scheduling 5 days a week on the hearings for various reasons. I mean, we all have other matters that we probably need to catch up on those dates, so we really appreciate that.
Thank you. I understand and agree with all your points. And as I said, this initial, I will be issuing a notice of hearing, but it is intended as a, I thought about issuing it as a draft, but I'm just going to issue it and then we will amend it if we need to amend it. And I understand that all of you will, you may very well not know exactly who your witnesses are. So I understand those caveats. I think where I left off was CDFW. Do you have any comments?
I think at this time, the number of days should work and the dates generally look fine. November 3rd would not be super ideal for us, but we could probably manage it if needed. Yep, but otherwise fine.
Thank you. Santa Ynez River Water Conservation District.
I will defer to the other parties on the number of days. They seem to think it's good, and since I will only have cross or rebuttal, I'm going to take their word for it. I agree with you. Not having 5 days in a row is a blessing, and I thank you kindly for it. I think that on phase 1A of the Kern, we did that, and I don't want to do it again.
Oh,
and I'm sure you don't either. We did give you a half a day of your time back, though, at the end, I'd like to say.
It was efficient. We were all tired. We were ready to be done.
We were very tired. But yes, no conflicts that I'm aware of in that period you identified. Obviously, we don't know who our expert witnesses would be yet if we had any, so we'd want to check in with them. But at this time, those days are fine.
Thank you. Alisal Guest Ranch, Ms. Diaz.
No further comment. Thank you so much. For Alisal, no further comments on the date or length of the hearing.
Thank you. And ID1.
I think the time frame and the length is fine. I think we have kind of the same comments that the Santa Ynez River Water Conservation District had, but other than that, we're okay.
Thank you. All right, I think with that, and I appreciate all of your input and us taking the time to work through these, I think it will help us moving forward. I'd like to, maybe we can do items 2 and 3 together. What I have is item 2 is a discussion of length of time for oral summary of written testimony from witnesses. Again, I realize it's a little bit of a hypothetical conversation because you don't know how many witnesses you'll have necessarily. And then there's also this discussion of the deadlines for submission of NOIs, notices of intent to appear. The NOIs have 2 purposes. One is for me to know who plans on participating. I assume it'll be everyone on this call, but sometimes you get surprises. So those are helpful for that reason. And the other reason is that the NOIs involve listing out your witnesses. I don't intend, when I ask for NOIs, it is not my intent that it's written in stone. I understand sometimes things change. You may have a need to substitute a witness, that kind of thing. But it just gives everyone a chance, a better understanding of who your witnesses are going to be. Usually the parties can then anticipate what the subject matter of that testimony might be. And it also helps us with scheduling if we realize that we're suddenly, someone wants to call 12 witnesses, and then we might want to have a conversation about how that's going to work. So please don't do that unless you need to. So let's talk about, and then the additional point is there's a deadline for submission of NOIs and then deadlines for submission of evidence. The city had laid out some proposals for deadlines for submission of evidence, which I think I'd like to work from. And let me talk those through now. What I would anticipate for NOIs is that those would be due before the deadlines for submission of evidence. I think it's helpful to know in advance, so that we'd be looking at, I think, sometime in mid-August for submission of NOIs. As I said, that's not setting your witnesses in stone. If there needs to be an amendment later, we can do that. But as an initial identification of witnesses, Then the proposal is September 1st for submission of case in chief, written testimony and exhibits. A proposal of October 6th for submission of written rebuttal testimony and exhibits. And then we'd have the start of the hearing on probably on November 1. As I said, typically I've started from the presumption of about an hour for each party to present summaries of its witnesses' written testimony. Now here where we have 3 parties who are planning to work together, my anticipation would not be that you get 3 hours to present summaries, and it seems unnecessary, but that you would aim towards whatever number we decide on, but approximately an hour. Now, if there's particularly complex technical expert testimony, I understand sometimes it takes more than approximately 15 or 20 minutes to summarize that testimony, and it actually is helpful for the hearing officer to work through that in more detail. So if there's a reason for that, I'm certainly willing to consider that. But I wanted to put out there just as an initial, it's not written in stone, but an initial target of approximately an hour total to summarize all of your witnesses' testimony. Typically, the way this is done is by the witness, not the attorneys. I usually grant just 5 to 10 minutes for opening statements. So if you wanted something longer than that, we should talk about that. But usually 5 to 10 minutes is plenty to summarize where you're going with your witness testimony. So with all of that information on the table, I'm going to go around the room and see if you have any comments about any of that. I will start with the City of Solvang.
Thank you. Excuse me. That sounds appropriate, and we appreciate that if the fisheries parties are going to be working together, that their time would be kind of as a block, consistent with Solvang as an entity. So that sounds appropriate for us. Thank you.
Thank you. And I should add, at this time, I wasn't planning to put limits on cross-examination. I don't think I have in the past, but I also haven't, and it seems to work fine with, I will have active management in the proceeding. If the cross-examination is not moving along and is not productive, then I would ask for you to move it along. And that usually seems to work. And that I don't have to put, it doesn't seem to be particularly helpful to put specific deadlines in advance, but we can also examine that issue. But that's where I am on time limits for cross-examination. I typically don't in advance, and it seems to have worked. Before I move on, Mr. Kim, do you have anything to add?
Yes, so the 1 hour suggested limit that we had in our statement was an assumption of the time limit for opening statements, by respective counsel. Perhaps we had a little misunderstanding with respect to the summary of a testimony. We thought that was part of the opening statement, but if the pleasure is to have the actual witnesses give a summary of their testimony that is already submitted in writing, then we probably need to work through the logistics of that. What if they are expected to give that summary at the very beginning of the hearing, then we just need certainty that is the pleasure of the hearing officer, so that we have those witnesses available that day, as well as on subsequent days for anticipated cross-examination.
Right, thank you. And maybe this is a chance for me to clarify as well what I envision and what has occurred in other proceedings. Typically, the way I've run my other proceedings, well, there almost is no typical, but in the past, what has worked well is that we would start with here. I would anticipate that the City of Solvang would be the first party to put on their case in chief. That you would start with an opening statement. If you did think there was a need for a lengthy opening statement, which I realize you're trying to understand where all of this goes. But if you thought there was a need for a lengthy opening statement, I would probably be more inclined to ask then for just opening briefs and have those in writing. If you thought you needed more than 5 to 10 minutes simply to summarize where you're going. And opening briefs are an option that we can talk about. I don't know that we need to set that today. If we're going to be meeting again, we can defer at least that issue until a later date. But typically opening statements are 5 to 10 minutes, and then we would move directly into your witnesses. The way we've done that, I have done panels, but I really find that it seems more efficient to put on witnesses individually. So each witness would have an opportunity to present a summary of their written testimony if that seemed helpful and appropriate. And then we would go directly to cross-examination of that witness. And we would work our way through all of the city's witnesses in that way. And then we would turn over, presumably in this case, to the group. We need I guess the fisheries group would be an appropriate name. And then they would have an opportunity to provide first an opening statement and then presentation of their individual witness with cross-examination occurring after each witness as we move forward. So that's generally how things have proceeded. So I wanted to clarify and lay that out. With that in mind, Mr. Kim, is there anything else you'd like to add at this time before I go around the room?
No, just for clarification in my mind. So the expectation is, there's an opening statement, and then, so for example, City of Solvang witness number 1, there would be a short summary by the witness of their direct testimony. Then there would be cross-examination, and once the examination is concluded for witness number 1, then witness number 2 for the city would then also give his or her summary of their testimony that has been presented, and then we go into cross-examination, and that's how the sequence is that you've outlined, correct?
Correct. Thank you, Mr. Kim. And I should add to that, to be perfectly clear, I realize I skipped some steps in there too, which is, as you indicated, there would be witness number 1 would offer a summary of their written testimony. I would allow for cross-examination by all of the other parties. I would then allow an opportunity for you to redirect the witness if appropriate. I typically do that. And allow, if appropriate, for recross from the other parties. Somewhere in that process, I may have questions for the witness and I will ask them. Typically, I'll do that before you redirect your witness, so that if I bring up questions that you want to elicit more testimony from your witness about, you would have the chance to do that. Members of my team may also have questions, and I will allow them to ask questions. So I wanted to clarify, there are usually additional steps, and I usually would allow for that. And then we would proceed to witness number 2. And that's generally how it proceeds. Thank you for thank you for the opportunity to clarify this. I think then you can get in your mind, we can all get in our minds how this might proceed and the best way to do this. With that, I will go ahead and turn to NIMS. Do you have any comments on the presentation of witnesses, as well as the deadlines for case in chief evidence submittal and rebuttal evidence submittal? Ms. Beal, go ahead.
Can you hear me? Because my audio suddenly got a little bit fuzzy.
Oh, I can hear you fine. So thank you.
Okay. Of course, just when you call on me, I'm having a little bit of screen freeze going on here, but okay. Couple comments. Generally, yes, the deadlines all sound good. I don't think this is at all in conflict with the process you outlined, but I do want to make it clear that although we, the fisheries group, so to speak, do want to be as efficient as possible in trying to coordinate our testimony, we do have each entity has very different authorities, and if there's a need to make sure that we have the sufficient amount of time to each present our own perspectives. I just want to highlight that. Like, obviously, as a federal agency, our role is going to be very different from a state agency versus an NGO. And then, so my only other question was in terms of the witness doing a summary, can that also be a little bit of a direct format, like a little bit of a Q&A? And I ask that because for our experts, this is very far outside their normal, what they normally do at work, and they might be more comfortable if I frame it in terms of a few questions I ask them to present their testimony rather than telling them to just sort of start summarizing.
Thank you. That's helpful. Yes, I have seen attorneys choose to present the summary of written testimony in that way, as formatted as a direct, and I think that's fine. The one caveat to watch out for is because the submission of written testimony is required in advance, you do need to take some care that the testimony you elicit on direct is not outside of the written testimony. So it would need to be anything the witness is saying on direct or as a summary must have already been submitted. Now, this is not the case on cross-examination, then you can go outside, obviously, the scope of the written testimony. But in that direct, just taking care that your questions elicit responses that where the information is already in the written testimony. That has come up as a problem where the witness was inspired to be more detailed on direct when we were in the hearing, and some of the information wasn't possibly wasn't in the written testimony. So with that caveat out there, sure, whatever is most comfortable for you and your witness, that works fine for me. Thank you. California trout.
That all sounds good to us. And just again, sharing those concerns that we'd have adequate time with our 4 different experts. And then we'll probably need to address how to deal with the different counsel in that time period, and whether it makes sense to sort of pivot between the 3 of us as we switch to different experts, or if you want it really to be a joint presentation.
Thank you. And I'll probably leave most of that up. I'll leave that up to you. I mean, you can ask me my opinion of what I, if you want to know what I think might be most useful, but probably I'll say, well, however you think the presentation would be most useful. And I did want to caveat, I recognize that the 3 of you are representing different perspectives in many ways, and I do appreciate the coordination working together. That does make this process much more efficient than if you were to present your evidence independently. So thank you for that. California Department of Fish and Wildlife.
Yeah, I think we would echo the same concern Maggie just brought up about coordination among council and potentially adding some buffer time there to allow for that. And then if I heard correctly, you were sketching out about an hour for the combined witness summary of testimony. I'm a bit concerned with the number of witnesses and the technical nature, that maybe an hour we could use a bit more of a buffer there, but defer to your judgment.
Thank you. And I'm open to setting that out, especially it may be appropriate to re-examine that once you have more certainty about how many witnesses you have. So I'll put a placeholder in our notice of hearing, and with the idea that we can re-examine whether it's an hour or we end up something like an hour and a half. That may be appropriate. So, and then as we go forward, as with, if there's good cause in any of these, and I find a particular summary or particular information to be helpful to me as we go forward in the hearing, of course, I reserve the discretion to allow more time or move us along as is appropriate. I'm just going to look to the remainder of the parties, because you're not at this time planning on presenting witnesses. I will just look, please unmute yourself and speak up if you have any other comments on this issue, on these issues that we've discussed about presentation of witness summaries and then the deadlines for submission of evidence.
This is
Gary Svistad for ID1. We would not obviously be, well, I guess we're kind of sitting on the fence here watching, but we wouldn't anticipate submitting a NOI at the beginning in August, as you do, because we would not have seen the direct testimonies yet. So we would not probably submit that until after we see the direct testimonies to see if there's any issues we need to address. And then we would anticipate filing any rebuttal to that, and maybe doing the NOI at that time as well, when we know that there is, if an issue comes up, we need to feel to address.
Thank you, Mr. Vistad. That makes sense to me. I think, as I said, these NOIs tend to evolve as more information comes in, but it's helpful to have at least the initial foray up front. So we know about case in chief witnesses. Those typically what is in the initial NOI is a list of case in chief witnesses. I wouldn't expect you to identify your rebuttal witnesses until you know what you're rebutting. So that makes sense to me.
All right,
Mr.
thank you.
Stroud, I saw you come off mute as well. Please go ahead.
I was actually going to raise something about the same issue. I think what I recall we did on the Kings that worked well is we had 2 NOI deadlines, and parties that only wanted to do cross and potential rebuttal, but they obviously didn't know what their rebuttal was yet, indicated that in their NOI. And then we had an amended NOI deadline that came with the rebuttal evidence. And I thought that was elegant. Maybe we should do that.
Well, if you're going to call it elegant, they're going to require to do it that way. That makes some sense to me. So I'll look at whether we have setting some kind of amended NOI deadline in this hearing notice that goes out. Anyone else on these issues before we move on? My plan is to next move on to deadlines for evidentiary objections. But anything on this?
Just one comment from CFW's perspective, and I don't want to speak for Cal Trout and NIMS, but if it were the case that Alisal and or ID1 determined that they needed to rebut some portion of direct evidence, and they were submitting such rebuttal along the same time frame as the other parties, it would seem to me that City of Solvang or the fisheries group might then have a further response to that rebuttal. And so I guess what I'm suggesting is either if one or more of those parties were to intervene on October 6th, then we would have basically, I guess what I'm asking, is there a final pre-hearing brief that we would be able to, as a vehicle, to respond to that rebuttal or something along those lines, or would it be appropriate to set a rebuttal deadline or sort of an intervener deadline for those other parties somewhere between September 1st and October 6th?
Let me make sure, let's examine this so I make sure I'm understanding, because at first I thought you were talking about rebuttal, but then maybe you're not. So you're not talking about an opportunity to respond to, for example, Alisal or the conservation district's rebuttal witnesses. Can you clarify for me more what the concern is exactly?
Well, I guess what I'm suggesting is based on, and this is just my quick notes while you were speaking, we're saying case in chief from all parties, all the identified parties at this point, would be submitted on September 1st. And then rebuttal evidence and rebuttal exhibits would be submitted on October 6th. And if the other entities determined that it was in their interest to submit some kind of rebuttal or response to the case in chief, and they do so on October 6th, then the city or this fisheries group might have some further response depending on what their rebuttal, the substance of it. And so I guess what I'm asking is, would it be appropriate then to at least give another 2 weeks or so for the primary parties to respond to these sort of intervening parties, or would it be appropriate to require the intervening parties to speak up a week or two earlier so that rebuttal can be more fulsome?
I see, staggered deadlines. So, or we can just call this rebuttal, which I think what this is a request for rebuttal. So keeping in mind the way these steps proceed, evidence submitted during rebuttal is evidence that truly responds to case in chief evidence. I have excluded evidence because I thought it ought to have been submitted with the case in chief portion. It's not a chance to sort of sandbag, and I'm not suggesting anyone here would do that, but that's not what the intent. Now I can understand here there are interested parties who only really need to participate if certain issues come up in the case in chief, and you don't know if you don't know what the evidence will be or if it's going to come up until that evidence is submitted. I certainly appreciate that. So
I'm driving at, yes.
I think maybe the way to deal with this, I have been hesitant to allow for rebuttal. I've allowed it in certain cases. It takes, it's an additional step. And often it's unnecessary, in my opinion. You really start getting down into the weeds. So I'm not inclined to do it. However, if we get that case in chief, let's take this step by step. I think we're all going to know more. It's difficult to address this in hypotheticals. I don't think staggering the deadlines for different parties is going to help us. I think we sort of run into the same problems, because then those parties will say, well, I want a chance to respond to the other party's response to my response, and we kind of get in the same place. So I think I'm recognizing that this can be an issue. I think we should deal with it down the road and continue to think about it and deal with it down the road. We will all know a lot more once that case in chief evidence comes in. And even before we get to rebuttal, we'll know more at that point. And I think we'll have a better chance to address those issues at that time. The other note that I will say is if that case in chief evidence comes in and all of you look at it and think we need to meet and talk about how we're scheduling this hearing and whether this even the structure works, we can do that. We can set a pre-hearing conference and come back together and talk about that. I'm certainly open to that. We do have the benefit. We are working on this. Well, it's April and we're talking about a hearing in November. So we're good for us, pat on the back. We have some time to work through these things. So I appreciate your comments. You're welcome to respond. Do you have anything else that you'd like to raise at this time?
No, that's all. Just an issue to flag, and as long as we're open to discussing it further at some point down the road before hearing, that satisfies my concern.
Thank you. I appreciate it. So I believe where we are now is moving to talking about the deadline for evidentiary objections. I think both groups suggested deadlines that were very shortly before the hearing. My practice has been when I get written evidentiary objections is to rule on them in writing, which means I need them sooner than right before the hearing so that I have time to work through them carefully, and then what to do with your witnesses. Now, I did want to caveat before we get into this question of evidentiary objections. I know we want to have a clear understanding of how that might work, but I do want to caveat for all of you, if you've participated in other AHO proceedings, at least with me, I think you've seen the pattern that it's fairly unusual for evidence to be excluded or limited. This is an administrative proceeding. The normal rules of evidence, I don't want to say normal, the court rules of evidence don't generally apply in these proceedings. The presumption is that the evidence, if it's relevant, it's going to come in. Hearsay is allowed, so that's going to come in. So there are some bases in which I think evidence and testimony can properly be limited, but it's not often. So generally speaking, evidentiary objections don't move us along. So it's something to think about whether it's worth your client's dollars to go through that exercise. But it happens. You can look at the past proceedings on the AHO website. There are times when evidence that really wasn't relevant to the hearing issues was submitted by a party, and then we want to clean that up and streamline our process, and it's important to do that. So I did want to give that caveat. My general thought, looking at the deadlines of September 1st and October for case in chief and October 6th for rebuttal, is that we would have a September 1st case in chief evidentiary deadline, and that any evidentiary motions objecting to that case in chief evidence would come in 2 weeks later on September 15th, and then any responses to those objections on September 22nd, which would give me then a chance to rule on those motions, hopefully before the deadline for rebuttal evidence. Now, it does mean you'll be working on that rebuttal evidence before you exactly know whether it's, some of your evidentiary objections to the case in chief evidence is what's going to happen. But as I said, it's unlikely that evidence is going to be excluded. So it seems fair to work forward on your rebuttal, assuming that evidence is going to come in. And then generally a similar proposal, slightly shortened, but a similar proposal for evidentiary motions on rebuttal evidence, which would be to have the initial motions due on October 18th, and then responses due on October 24th. And that, it once again gives me time to rule on those in advance of the hearing, which I think is helpful for everyone. And helps us, we come in on hearing day one knowing what evidence is in or out. So in looking at those deadlines, I will propose deadlines. Again, recognizing that those may be amended if we move forward and find that something different would be more efficient. I will look to the city of Solvang. Do you have any comments on those deadlines or the process for evidentiary objections?
Thank you. Of course, once we see all of this in the calendar, once you issue your order, I think the exact dates we'll have to look at and stuff, but the general process you outlined makes sense. And we appreciate having the determination of any evidentiary issues before the hearing and for the case in chief issues before rebuttal.
Mr. Kim, do you want to comment any further on that?
Yes, if I may, the process that you've outlined makes a lot of sense. The only question, concern, or ask, depending on how you receive it, is as you mentioned, the rules of evidence and standards for exclusion are a little different in these proceedings than in Superior Court or otherwise, and so I don't know if it's feasible or possible, but anything that you can give the parties in terms of guidance, in terms of what is allowed or not allowed, and examples or some guidelines, so that there isn't there's better expectations of what should be filed for motions to exclude or eliminate, and what should not. I think that would be helpful for the parties to hopefully minimize, or at least give guidance for any motions to eliminate.
Thank you, Mr. Kim. That's a helpful suggestion, which I will take to heart. I think our standard hearing notice template just generally refers to the standard for evidence in administrative proceedings, which is a starting point. It's somewhat helpful. So there will be that. But I think what I'll do, if I remember, and I'm making a note so I will remember, is to point to some evidentiary rulings that I have drafted that include discussions of what I see as the applicable standards in law and some of these issues, which hopefully will be helpful to the parties, just as examples from past proceedings that I've been involved with. So I will try to provide those, and thank you for the suggestion.
Yes, I think that would be very helpful. Thank you.
Thanks. NIMS, turning next, Ms. Beal.
I don't think we have any other concerns. I'm wondering if there's any specific procedure for qualifying experts, but that would be my only other question.
That's a good question. There isn't, and I will try to pull in these examples. I will try to pull. There are specific rules about expert witnesses that do apply in administrative proceedings, and I will cite to those provisions. They're in the hearing notice, but I will be sure to cite to those provisions. And I will see if I can pull. I think I have past evidentiary rulings specifically on that issue of the competency of experts to testify to particular issues. But it is not quite the same as what you'd see in Superior Court, because the standards are different. I mean, here the idea of the administrative proceeding is that first of all, you're not presenting to a jury, so there's less of a concern about confusion in theory. I have some expertise in the matter, and I'm being assisted by those with technical experts, so we can sort through what is relevant, what is helpful, and the competency of experts to some extent. But I will try to provide some additional, at least examples. It wouldn't be exactly guidance, but at least examples, if to the extent I have any. So thank you. Cal Trout.
No concerns about that proposed schedule for us at this time.
Thank you. CDFW.
The schedule works for us as well. Thank you.
Great, thank you. The Santa Ynez River Water Conservation District, Mr. Stroud.
No concerns with that approach. I think making sure that you have time to get that written ruling out on the evidence issues before the hearing is extremely beneficial. So whatever you need for that, I'm in support of.
Thank you. I appreciate that. Alisal Guest Ranch.
No concerns about the proposed schedule.
Great, thank you. And ID1.
We're fine with the proposed schedule, and we appreciate your flexibility in addressing our participation.
Thank you. Taking things slightly out of order, I did want to mention, I appreciate all of the input on closing briefs. I'd like to just come back to that later because our pre-hearing conference is already a bit long and I don't think we need to fix that quite right now. So let's set that aside, but I do want to have closing briefs and we'll just make sure we come up with an appropriate length and deadline for those. So my next question is going to be, I'm going to combine these together. Whether there are any other pre-hearing deadlines. Actually, let me do this a different way because I think we have two other issues we want to talk about. We'll put these together. The city of Solvang talked about a site visit, that might be appropriate. I think the proposal was to do it after rebuttal evidence was submitted, but before the hearing started, which would put us, I think that was the proposal, but we can talk about this. That would put us between October 6th and November 1st. So one of my questions is, one, just generally, would a site visit be productive? I'm inclined to say yes. If it's being proposed, then probably there's something. There's nothing with water proceedings. There's nothing like looking at the actual plumbing, if you will. So I find that I think it would be helpful, but I would like to hear from all the parties about whether that's an efficient use of our time. And then my second question, is this a good time of year to go? I know obviously the time of year influences what you see quite a bit. I know we're somewhat limited in our timing possibly, but it is a question of whether that would be a helpful time to go and do the site visit, whether there's reasons to do it earlier or to try to do it later or at some other time. The second issue that came up, I think the fishery agencies raised it, was the issue of pre-hearing discovery. That has not normally been a process, a part of the AHO proceedings. It can be. I mean, there are provisions for that in the California Code of Regulations for our proceedings. So I would be interested to know if any of the parties anticipate attempting to conduct any kind of pre-hearing discovery, because we probably would want to talk about that and set up some kind of discovery plan and set up timing for that. So I would like to hear from you if you anticipate that being a part of this proceeding, although in this case where it's a permitting process, I guess I'd be a little surprised if that would be productive, but it may be. You could explain that to me. And I realize the question may have just been for general understanding, so we can talk about that. So on those two issues, and then the third is, are there any other pre-hearing deadlines we should be setting or talking about today? So site visit, pre-hearing discovery, any other pre-hearing deadlines that we should be talking about. And with that, I will turn back to Ms. O'Sullivan.
Thank you. Yes, the city asked about the site visit mainly because that was something that was included in a prior scheduling order from Alan Lilly. So we're amenable to that and are interested in the other parties' views on that. As far as pre-hearing discovery, we do not anticipate that would be needed. As you said, this is a permit, not an enforcement action. So we don't see that would be helpful or productive. And we did not have any other pre-hearing deadlines. Thank you.
Thank you. Will you clarify for me whether the site visit, I appreciate that you're amenable and welcome to, or willing to make it happen. Do you have a position one way or the other as to whether that would be helpful or not?
I think it could be, some of this might be determined when we have a better sense of our case in chief scope, but we wanted to put that out there as something that is a possibility since it was included in previous potential schedules for this proceeding.
Thank you. I remember that now. So thank you for pointing that out. Mr. Kim, do you have anything to add?
Sure, thank you. It's my recollection that the site visit was an ask by the prior administrative hearing officer, Mr. Lilly, and he thought that would be a great value for him, and so we are accommodated that request, and we included that in our statement. If you believe that a site visit is unnecessary, perhaps after seeing some of seeing the direct testimony, or if you do think that that is something of value, then maybe that's something that we need to revisit after the submission of direct testimony. So, and then in terms of the pre-hearing discovery, like depositions and the like, Just going back to my experience in CPUC proceedings, those have been largely unnecessary and prohibited in CPUC proceedings. And Mr. Lilly also had very strong feelings about the unnecessary nature of depositions and pre-hearing discovery, just because of the nature of how the testimony is presented well in advance. So we don't think discovery or depositions are necessary. And I'm not aware of any other pre-hearing deadlines at the moment.
Thank you. I appreciate all of those comments. I'll turn next to Ms. Beal with NIMS.
Yes, in terms of the site visit, it seems to me that it could be useful. In terms of your, I think that's appropriate to consider not only the time of year, but that it is potentially a highly anomalous water year due to the storms that we've had. So if we do have the visit prior to any of the testimony, I'm just wondering if there's a way to have some information made available to all the parties in advance of the visit to try to explain what we would anticipate seeing this year versus looking at like a hydrograph, some sort of average over time, to be able to take that into the context where we are right now. But I hadn't thought of this before you mentioned it, so I'm thinking a little bit on the fly here, but it seems like that it would be important to make sure that we all have context around what we would be seeing versus what we might have, what we might have seen had we done this last year, for example.
Right. That makes sense.
I don't have comments on any of the other questions. Personally, we weren't intending to engage in discovery, and I'll let the other parties speak to that, but I believe it was more just ascertaining if there was anything else we should be considering.
Thank you. I appreciate that. Cal Trout.
Great. As for the site visit, I also remember that came from the original hearing officer, and we're certainly open to it. I'd want to confer with our expert team as to what time of year would be most instructive. And again, I like Ms. Beal's approach of providing a comparison to normal conditions. That would be helpful. And as for discovery, again, was not part of our plan, and I cannot think of any other pre-hearing deadlines at this point.
Thank you. I think I will just turn once again as a group to the remaining parties. Do you have any, please feel free to unmute if you have any comments on these issues.
CDFW has.
Oh, I'm sorry. I
things.
skipped CDFW.
That's okay.
Please, I apologize. And then I will turn to the other parties. Thank you.
No worries. Thank you. Well, a few things. We just wanted to point out, as far as the proposed timing, it's likely that that period of time would be in the driest part of the year. So it may limit the aquatic resources that you're able to see on site that otherwise would be there at different times of the year. So if there was an opportunity to be able to dialogue or point out the limitations of the conditions, that would be helpful. Also maybe limits on just surface water generally flows that are there as well. And I think, I'm sorry, it might also be an anomalous year just in general. So you might see even lower flows given conditions at Lake Cachuma. And if I'll give my biologist a chance to weigh in on that as well, if there's more to say there. But just first, before that, just also wanted to check on the timing. I think our preference would be to have the site visit maybe before the rebuttal, but after the case in chief exhibits, because maybe the primary exhibits would inform the site visit. But yeah, we have a slight preference for having the visit before the rebuttal submissions, if that makes sense.
Okay. Thank you. Now I will turn to the remaining three parties. Do any of you have any comments on these issues?
This is Gary Kubistad for ID1. My only comment would that the physical scope of the site visit be identified ahead of time and limited in scope to the area that we were talking about, and then that the hearing officer would issue some sort of procedures on the conduct of the site visit, as far as what's going to be, who's going to lead it, how it's going to be, things pointed out, how you're going to move around the river, so that everyone has equal opportunity to see what they need to see and participate.
Thank you. That yes, I would plan to do that. I can certainly understand the concerns related to the scope and the agenda and who would participate and how it would be recorded. In full disclosure, I have not yet conducted a site visit in any of my proceedings. It just hasn't come up yet as something that was helpful and efficient. This may be the first if we end up deciding to do this. Now, that said, the other hearing officers have conducted site visits. We have procedures that I can build on. That certainly comes with setting up an agenda, having an opportunity for everyone, all of the parties to participate in that visit. There is structure in what conversations are had and what can be said. We also have, the AHO has a GoPro camera which will be used to record the relevant portions of the site visit where there are conversations, and to document what it is we're seeing for the administrative record in the proceeding. So that has been our practice in the past. Caveat that I have not personally done it, but we would go forward in some orderly way and make sure that we're all comfortable with what is documented for the record, so that there's full information about the content of the site visit, and we all know in advance what is going to happen, where we're going to go, and what we're going to talk about when we do that. So I anticipate
one other.
That, yes, please go ahead.
One other thought: if the site visit might be too cumbersome, I wonder if, given our advancement in technology, if it might be helpful instead to do a site visit via drone and have a drone record this area of the river, either at the later in the fall or maybe a couple times between now and the hearing, so that the parties could observe the river in different conditions this year.
Thank you. I appreciate that comment. It's certainly something I would put out there for the parties. Initially, I think I would turn to the parties and ask if you maybe would continue to discuss that possibility. That could be something I could envision if you were able to conduct a visit. It wouldn't necessarily have to be live, but by drone, where you would compile, agree on certain parameters, acquire some footage, and then stipulate to any whatever is relevant in terms of the authenticity of the video and that type of thing, and then submit it as evidence. That could be very helpful. And it's one possible way where, depending on how we talk about this, that may be more efficient than all of us going out there. I don't know about the accessibility of the relevant parts of the watershed. So that's something I would like you to discuss further.
Yeah, that's why I suggested. I think it could be quite a bit more efficient than trying to move around in the river with a large group of people.
Thank you. I think Mr. Kim, I see your hand. Let me turn to Mr. Stroud first, because I think he had something to say, and then I will turn back to you, Mr. Kim. Thank you.
You know, you already addressed what I was going to ask, which was about how it would be documented. I don't have a strong opinion about whether it would be productive or not. I just wanted to see how that would be treated in terms of the administrative record.
Thank you. I appreciate that. Mr. Kim.
Yes, I just want to reiterate that the city didn't have any strong opinion one way or the other as to the site visit. It was really more of Mr. Lilly's ask. And so I think it would be appropriate for you as the new administrative hearing officer to keep it within your discretion as to whether you think that a site visit is helpful and necessary for your more complete understanding of this project and the issues. It sounds like just based upon what I'm hearing, that there would be a tremendous amount of resources that would need to be devoted if all parties were participating in a site visit. So I'm all for trying to streamline a site visit if that is what is requested, and I do like the idea of some neutral site visit, like a drone survey, if that would be most helpful.
Thank you. I appreciate those comments. My intent right now is to set aside the issue of the site visit for us to all think about. I know we may not have been thinking about it specifically up until now. So let's revisit that issue at our next pre-hearing conference. We can talk about it further if there are other comments on that issue. Last on my list, I think we'll be setting our next pre-hearing conference. We'll start with looking possibly at July. I know the summer is difficult, so we will work on that. But before we go to, so bring up your calendars, look at July. And before we go that specifically, I will look to the room. Is there anything else other than setting our next meeting? And I should say my plan is that I would issue a hearing notice before, well in advance before our next pre-hearing conference, so that you have a chance to look at it, think about it, file pre-hearing statements if you think that's helpful in advance of that pre-hearing conference, so we can get the most out of it. So all of those things I would plan to do. But is there anything else procedurally we should talk about today? I know we've been together almost an hour and a half, so I appreciate your patience, but anything else we should address today before we talk about scheduling our next conference? So I'll turn first to Ms. Hall, please.
Just a quick question. I don't know if we would know at this time, but on the scheduled hearing dates, do you know the times of the days that we would need to have blocked off at this time?
Normally, I will say 9 to 5.
Okay, great.
That is my general practice. I have done a hard stop at 5 p.m. in the past because I realized some of us have hard commitments like picking up children and things like that. So when I say a hard stop at 5, I will hold us to that so that you can get out and do your lives or schedule other meetings or whatever you need to do in your evening. So that's generally my practice.
Great. That's exactly what I was thinking about.
Ms. Germanario, please.
Thank you. We had a issue raised in our statement just regarding the scope of issues for hearing. I'm assuming that would be outlined in the notice in some way. Correct?
Thank you for raising that. I intended to say something about that, which is yes, what I will plan to do, and it's really as important as all of these deadlines. I realize there has been some dispute or concerns about the scope of the hearing issues, and that those are of course important for you to know. So my intent is to issue this hearing notice with a proposed list of hearing issues, with the understanding that one of the things that it would be appropriate to address in pre-hearing conference statements and at our next pre-hearing conference is whether or not that is the right list of issues, whether they should either be narrower or broader. But I am going to, my homework is to go and look again at what you've all commented on about the hearing issues that were laid out in Mr. Allen's, Mr. Lilly's initial hearing notice in this proceeding, and think about, I know developments have occurred since that notice was issued. It's been a couple of years. So I may make amendments to those, but then you will have a chance to respond to what I put in that hearing notice that I will issue. So thank you.
Thank you.
Sir, are there any other comments before we turn to our calendars for July? Excuse me while I turn to my calendar for July. So I think I will turn first and ask, well, let's see, what is the most orderly way to do this? I'm inclined to skip the July 4th week because I anticipate that that won't be a good one for us. So let's start with the week of July 10th. And maybe I can see, just please, if you would raise your virtual hand or your actual hand on video, If you have any conflicts, maybe I'll just pick a day. Or is there anyone who can't do any day the week of July 10th? We'll start there. Mr. Stroud.
July 12th would be bad. Other than that, fine.
Okay. Not July 12th.
I do have a, oh, go ahead.
Please go ahead.
I have a potential conflict at this time that week, just potential travel plans, but nothing set in stone at this time.
Well, we can look to the, it doesn't matter. I mean, as far as I'm concerned, we can wait a week. So if we can find another week, let's look to the following week. And if we can schedule it then, we will do it then. So let's
if
now
I can,
sure.
I am actually going to be on vacation from July 13th through the 23rd on international travel. So
understood. This is what I knew the summer would be difficult, but we will get there. I think.
I hate to even say this, but I start a major trial on the 26th.
Okay. That's okay. So you're busy. I mean,
a little bit.
Let's say, well, so let's go back and look at, so it sounds like we may actually best look to July 10th or 11th, recognizing that there is a potential conflict, but that's not set in stone. So let me look back to July 10th and 11th. Are there any of you who have irreconcilable conflicts that you know of for July 10th or 11th?
This is Gary Kvistad. I have a conflict on Tuesday afternoon after 2:30.
Okay, thank you.
And this is Tilden Kim. Looks like July 10th, I have a court appearance at 10 o'clock. Those usually run about an hour and a half. So I'll be good anytime after noon, 12 o'clock or after.
Thank you. So I am going to narrow this down for us and propose we look at the morning of July 11th. Are there any conflicts with that that are known right now? Okay, so normally I start these at 9 a.m. I didn't today because I had another meeting this morning. So let's go ahead and plan on, for now, July 11th at 9 a.m. If something irreconcilable comes up, you may let our office know in writing and we will try to work through that. But for now, let's plan on July 11th at 9 a.m. I will issue a pre-hearing conference notice with that notice of hearing that will come from our office. I will do that soon. We're pretty far along on the hearing notice. I need to look at the issues, but it will come out well in advance. I will set an appropriate deadline for pre-hearing conference statements. They'll be optional, but I will set a deadline in advance so I have a chance to see those and we all have a chance to look at those as they come in. And with that, is there anything else we should address today before we break? Ms. Germanaria, you're on mute.
Yeah, thanks. I'm not sure if this was addressed already, but I think both Solvang and CWW had parties on the service list that needed to be edited.
Yes, we saw those. I believe we have taken care of them. If you see any errors that remain or changes that need to be made, please let our office know in writing. Just send us an email. But I think we have addressed both of those. So thank you for reminding me.
Thanks.
So with that, I just wanted to thank you for your patience. This is a long, normally we don't go this long, but we had a lot of issues to work through. I really appreciate all of your input today. I think it was very productive and I look forward to seeing all of you in July. Thank you very much.
Thank you.
Thank you.
Thank you very much.
Thank you.